Hi, this is Lisa DeMonte from mylegal.com. It's Tuesday, March 23rd, and we're here for the third and final day of the conference at the Georgetown University Law Center, Law Firm Evolution, Brave New World, or Business as Usual. I'm absolutely delighted to have as my guest this morning Michele DeStefano Beardslee. Michele is an associate professor of law at the University of Miami Law School, and she has written a number of papers, and Michele was also a panelist on one of the discussions yesterday on emerging trends in legal services. Michele, thank you so much for joining us today. We're delighted to have you here.
Thank you for having me.
Welcome. Michele, what's the focus of your research?
Basically, we went out to try to study how the corporate legal market is evolving. So basically the relationships between large corporations and law firms. How do large corporations purchase legal services?
What are the key findings of your research?
Well, we have a few. The first is that convergence, which is the legal jargon for when large corporations whittle down the number of law firms that they use, in this large corporate legal market, that it's pretty much stable. So right now we found that approximately 80% of a corporation's legal business is going to between 12 and 20 firms, and that over 50% of the law firms in our study, of the corporations in our study, have only changed law firms in the past 3 years less than 2 times. So that really shows that convergence has evened off. And then in terms of how large corporations purchase legal services, the number one criterion is relationships. Relationships is the dominant factor, who you know. And this was true both in our survey, which we sent to the entire S&P 500 and elicited a 28% response rate, and the interviews that we conducted with 43 CLOs in the S&P 500. Those are the 2 primary factors, but the other finding that we found was that contrary to the literature, terminations are really rare. So relationships are actually very sticky. Less than 20% of the respondents to our survey report that they've terminated more than 1 time in 3 years, and over 30% say that they haven't terminated at all. That doesn't mean there aren't repercussions, right? Mm-hmm. So although they're not being fired, there are repercussions, and it's something that's been coined as the penalty box. Mm-hmm. And the penalty box is similar to an adult timeout. But what we're finding is that the large corporations, or the CLOs, they're not just decreasing work to the law firm or to the individual that they're not happy with, but they're decreasing the work to teams, or departments within the law firm. And that's one of our major findings, this idea that teams are really the focus of the hiring and the terminations or reduction decisions. So another finding is what's the most common reason for terminations? Quality, expertise, but also conflicts, and not just conflicts of interest, not just, oh, you're suing me or you're representing my competitor, but business conflicts. So business conflicts in the sense that you're representing somebody or in some issue that may eventually lead to a conflict of interest. And I rely on you for some type of legal capacity insurance that when I need you, eventually you're going to be there for me.
And won't have any conflict with another competitor, perhaps.
Exactly. And so it's about loyalty. That's my lawyer, and here you're doing that. And so even though it's not one of the model rules of professional conduct, that the lawyer can't represent this individual, it's a common reason for reducing work or terminating. And then, as you know, there's a huge lateral legal market. So there's lots of movement, and consistent with that, we found that there are lots of star lawyers moving, and they're moving in teams. And before they move, they actually consult with the CLO, and the CLOs are following them, and more likely to follow them if they go with a whole team of lawyers, mm-hmm. as opposed to individuals. So overall, the old adage, or the recent adage, that you hire the lawyer and not the law firm, we don't know that we believe that that's so true today. We think that because law firms are managed like sub-units, these little powerful teams within law firms, that there are long-term, non-exclusive relationships with law firms that are based on this team relationship and approach.
That's very interesting. And you mentioned that, relationships were, the number one criterion used in maintaining that relationship. So how does that marry with the thought or the discussions at the conference about alternative fee arrangements and all of the evolutionary changes that we're seeing in the practice of law, seems that that would indicate to me, as a non-expert here, that those law firms are obviously adapting and making changes in that environment because their relationships with the corporation are standing. Well, is that true, or what do you see?
I don't know if you could say is it true or is it false. I think relationships really matter, and they're going to continue to matter, and that if there is trust and a long-term relationship between teams or individuals and CLOs, that they will continue to get the business. But CLOs are also starting to a la carte purchase legal services from different types of legal service providers with whom they'll make relationships. So there's more types of legal service providers that the relationships are competing with. But more than that, CLOs, we think, are going to have to and are probably going to start looking more internally at law firms. How are they managed? How are these teams being structured? And start to question things that they haven't been questioning. And this is because convergence has stabled, and they need to find new and creative ways to lower costs and increase services. So as a result, the law firms might start to have to justify the way they run themselves and the way they practice in a way that they never have before. But mostly what we think is something that you've heard in the last couple of days, that CLOs and law firms need to think about the relationship as one that's interdependent. So a sharing of costs and benefits. David Wilkins has an article about it. He calls it the legal keiretsu, which I can't even pronounce. Trevor Faurer talks about this as well. And we think that's the new evolving relationship, which is one that is even more interdependent than today.
Michele, one final question. What do you think the implications for the future are of CLOs, law firms, and educators?
So for CLOs, definitely that they're going to start putting their gaze on the law firms and how they actually structure and manage themselves. Law firms, there's some good news. We are seeing that long-term relationships exist. That's great news. And CLO turnover is about every 3 years, so it makes it even harder for long-term relationships to end quickly. But the bad news is these law firms might have to start justifying how they manage themselves and really try to figure out a way to manage these powerful subunits as a cohesive unit. For legal educators, for schools, the dinosaurs that haven't changed, it's time to change. We need to start educating law students about how to be business professionals, how to project manage, how to do marketing. I mean, not just finance and accounting, how to handle public relations, and how to work in teams. Business schools have been doing it for years. We need to train individual students on how to be a team member, what is an effective team member, how do you add value, and when you're selecting a law firm, not just which law firm and how to select it, but which team, because which team you're on can indicate your future.
So law students need to have a full package, so to speak,
yes,
to offer to
interdisciplinary, yes,
okay,
definitely.
Great. Michele, thank you so much for joining us this afternoon. Really appreciate it. Good luck on the rest of your research.
Thank you.